This video takes you inside a tense and emotional Bond hearing in Judge Simpson's courtroom involving a 19-year-old defendant, Mr. Hankey. The case begins with serious accusations that he violated strict court orders, including allegedly cutting off his court-ordered electronic monitoring tether. From the very start, the atmosphere in the courtroom is serious, as both sides prepare to argue whether the defendant should be given another chance or kept under strict custody conditions. The defense attorney steps forward and asks the court for leniency. They point out that Mr. Hankey does not have any prior felony convictions and argue that he should be given an opportunity to return to a controlled bond situation. They suggest strict conditions such as monitoring and limited communication, hoping the court will allow him some level of freedom while the case continues. However, the prosecution strongly disagrees and presents troubling details about the defendant's behavior. They explain that even after his bond was revoked, Mr. Hankey allegedly continued to violate rules, including making multiple phone calls from jail to the victim using different PIN numbers. According to the prosecution, these actions show a clear pattern of ignoring court authority and raising serious safety concerns. As the hearing continues, Judge Simpson becomes visibly frustrated, emphasizing that court orders must be respected. The judge carefully reviews both sides but ultimately focuses on the repeated violations and the seriousness of the allegations. The question becomes whether the defendant has shown any responsibility or respect for the law, or whether continued restrictions are necessary to protect others and maintain order in the justice system.
We're Kissy Hankey.
Your Honor.
Good afternoon, Your Honor. Attorney Kevin Hassan, except one witness.
All right, it's your motion.
There's probably a motion to take the previous PCC hearing. My client's bond revoked, his phone privileges from the jail suspended due to allegations that he cut off his tether and contacted the complainant. Following that particular bond hearing, my client not contacted a complaining witness, period, in the jail. Also instructed my client that if allowed to be back on bond, we would ask the court to hopefully reinstate his original bond with tether. We know judge that he has no prior criminal, no prior adult felony conviction whatsoever. Following the submission of my motion, I did read the people's response, which I guess there's been allegations that my client had contacted the complainant subsequently. Now, I just found out today some transcripts. Obviously, people address this, but some of the language that was used during conversations. I don't have phone conversations myself, but I will admit, Judge, that it seems that my client had contacted the complainant even after his bond. And so I say this, Judge, and again, I know it seems like my client is kind of throwing up his middle finger to the court.
Oh, yeah. Yes.
But Judge, I just would state that this young man, I think he understands now that the court orders are serious, that the court orders him to do something it means. So Judge, I'm just asking, I guess, for some leniency to trust that Mr. Hankey will comply. He had a $75,000 cashier bond that he was able to post to a bondsman. The only thing I can make sure that if the court were to give him a second chance, he would not violate his bond, even if the bond is a house arrest with strict conditions. So Judge, I am asking the court to reinstate his bond, and if the court is unwilling to do so, I would at least ask that his phone privileges be allowed back on to at least contact family. Does he never had any contact with his family, his children? He hasn't been able to contact his dad, caretaker for. So at the very least, the restriction of his phone privileges to contact family.
All right. Well, before I hear from the people, counsel, let me just say, you came in here the first time, and well, let me start with this. Where's our tether?
From my understanding, Judge, I thought community corrections still had it. I thought they had become.
No, he cut the tether off. We haven't seen it.
Okay.
And I know you made the representation to the court, but I know you wouldn't have personally known that. I'm sure that came from your client or something along those lines. We don't have the tether back.
Okay.
Then, and I get you're making the representation saying your client's going to follow what the court says, but I don't know if anything can be as shocking as walking into a court free. Your mom gets revoked. You get put in jail because of something that you've done, and then you still go about. I'll be honest with you, counsel. I mean, I get what you're saying. I don't have a problem giving people chances. I just don't know that this is the one to give a chance to, because he just hasn't done anything the court's asked him to do. Ms. Senda.
Your Honor, I will rely mostly on emotion. However, in listening to his jail calls, he has 45 total calls to one number after his privileges were revoked with different pins he's using. Then to the other number, we have 23 calls that were completed since his privileges were revoked with different pins. And in one of these calls, as recently as Monday, there were a few memorable quotes that I heard in the calls, such as, "There's not shit in this world that's going to stop me from talking to you, man. Nothing in this world's stopping me from you. I don't hook up what nobody says about none of that. I'm going to be calling until my court date. They're not going to do shit. At the end of the day, they can't do shit. I'm going to talk to you till I can't talk to you no more. I'll be home. I'm not worried, man. I know I told you this is about to be my last call, but I'm not stopping shit. I'm not stopping nothing." And then, why stop now if they already know? So I have extreme concerns that he cannot follow court orders, considering he cut off his tether, continued flagrantly calling the victim with other pins, both numbers, acknowledging in some of the calls that he should not be contacting her, and continue to contact her. He just cannot abide by any of the court orders that are set before him. So I have great concerns, and especially given the violent nature of this case as well.
Anything else, counsel? I mean, counsel, does your client want me to just request to the jail that they put him in solitary so that he has no contact with anyone, can't use their PIN number? If he thinks we can't do something, and particularly if you're going to look at this judge and think I can't do something, young man, you're going to learn a big lesson.
So I definitely don't want that. My client.
Well, he needs to, and I don't mean to interrupt you, counsel, but he needs to understand. You can say all that stuff. You are not that big, not that bad. Now, if you want to play with me, this is the kids say, mess around and find out. I guess that's not the quote, but yeah, it's close, but I did pretty good. I said it okay, right now. All right.
So just, if I may, just briefly, my client would like to.
Go ahead.
I want to apologize. I don't think I'm being bad at all. It's very about myself. I can't say that I'm not in here for nothing. You obviously think I am. Yeah. I just want to apologize. Like I said, I'm not being bad. I don't want to be here at all. I really don't. Truly. Again, please show mercy. Please. That's all that matters.
I have no problem showing mercy to those that deserve it and have earned it. You have not. Motion for bond reduction or any change is denied. His bond will continue as revoked.
Thank you, Judge. And for the record, this is also from my understanding the PCC.
Yes, sir. Is all discovery complete?
And I would ask if possible, if possible.
People have their witnesses available on the first.
We'll do our best, Your Honor.
Preliminary examination in person will be set April 1st, 2025, 9 a.m. in person before Judge Perry.
And Your Honor, I did want to make it clear where I did contact the jail yesterday, and they have blocked both of victims' new numbers and old numbers. So there should not be any more
More calls coming through. All right. Thank you.
Thank you very much.
In conclusion, this bond hearing ends on a very firm and serious note from Judge Simpson, who makes it clear that repeated violations of court orders cannot be taken lightly. Despite the defense's attempt to present Mr. Hankey as someone who deserves another chance based on his lack of prior felony convictions, the court focuses more on his recent actions and pattern of behavior rather than his past record. Throughout the hearing, the prosecution highlights disturbing evidence suggesting that even after being placed in custody, the defendant continued to ignore restrictions and allegedly made multiple attempts to contact the victim using different methods. This raises major concerns for the court about safety, accountability, and whether any form of supervised release would actually be effective in this situation. Judge Simpson carefully considers both sides but ultimately prioritizes compliance with court authority and the protection of those involved. The judge emphasizes that court orders are not optional and that violating them repeatedly shows a lack of respect for the legal process. As a result, the request for bond reduction is denied, and the defendant's bond remains revoked. The court also confirms that stricter controls have been put in place to prevent further unauthorized communication, and the case is scheduled to continue with a preliminary examination on April 1, 2025. Overall, this hearing highlights how seriously the justice system treats repeated violations, especially when they suggest a continuing risk of noncompliance.